everyone. So Kathleen Zellner has filed today on these whole the bones from the Manitowoc gravel pit that she wanted the rapid DNA ID test done on. So I figured we would read through this together. I have not read it all. I've skimmed through the beginning, but I was literally in Chicago all day. And so this came in while I was still driving back. So I haven't read it all. The moderators from Stephen Avery Project has. And so they've told me that a lot of it is stuff that we don't need to read and go over. So I'll just start reading and I'll discuss as I go on what I see. If you are asking questions while I'm reading all this, I will not be scrolling through your questions. I'm just going to be going through on my other screen here. I have the filing. The moderators have posted it, that it is in Stephen Avery Project, as well as in our Gossip Project. So if you want to read it for yourself, we have it available. So I'm just going to go through, we'll read these, and then we'll discuss a little at the end. And I'm supposed to be cleaning my house because my son's going to be here and his girlfriend, Jasmine. I don't know if Jasmine is watching since she's a Stephen Avery supporter. So so when they get here to bring me, they're making dinner for me tonight. My house will be messy, but we'll live, right? All right. So don't need to read that. Undersigned counsel has uncovered the state violation of Wisconsin statute blah, 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 where it failed to 1, preserve certain suspected human bone evidence, and 2, notify Mr. Avery and his attorneys of record of its intent to destroy such evidence. Mr. Avery hereby moves for a remand to the circuit court to conduct proceedings consistent with the claim alleged herein. Oh, and I forgot to say, if you do ask questions, the moderators are here, so they'll be able to answer your questions. All right, so let's continue on. Factual overview. The state's conviction of Mr. Avery was based almost exclusively on forensic evidence. At trial, the state told the jury that all of the incriminating forensic evidence was in close proximity to Mr. Avery's residence. Prosecutor Sweaty Sweat, in his opening statement, relied upon several computer-generated scene models which allegedly illustrated the location of incriminating forensic evidence and its link to Mr. Avery. Mr. Kratz, or Sweaty Sweat, claimed that Ms. Halbach was murdered and mutilated in Mr. Avery's garage and burn pit. Mr. Kratz attempted to link the following forensic evidence to Mr. Avery because of its proximity to his residence. A, the .22 Marlin Glenfield firearm above Mr. Avery's bed, which was identified as the murder weapon. Pause. All right, so that .22 that was hanging over Stephen's bed was not Stephen's. It was his landlord, Raleigh Johnson's. Raleigh testifies. You can find it on StephenAveryCase.org. That's Raleigh's. Has it ever been determined that for sure well, I guess it doesn't even matter. Doesn't matter if the casing that was found is proven to have come from Raleigh Johnson's gun, because Raleigh says he shot all the time over there. And if this was a planted bullet or casing or whatever anyway that they pulled out of the garage wall from Raleigh, shooting at varmints, it doesn't matter. But my boyfriend is an NRA instructor, teaches concealed carry, and is been raised with guns his entire life, and he's told me that the .22 is like your standard, that everybody who's a gun person has that gun, as evidenced by Scott Toddock trying to sell Bobby's 22 a day or so after Teresa had been at the yard. So, but I just always want to point out there when, they want to talk about that gun. Yes, Stephen was a felon. So he's not allowed to have a gun. And he's not a felon. People confuse this. He is not a felon because of Penny. He was a felon due to the whole incident with his cousin of chasing her off the road and pointing a gun at her. So therefore, he is not allowed to have a gun on the premises. So yes, it's Raleigh's gun that Stephen didn't use, but still, at the end of the day, Stephen shouldn't have had that there. So even if his conviction on Teresa is overturned, he still would be punished for being a felon and having a firearm in his home. All right, we'll go back. B, the bullet with Ms. Halbach's DNA on it in Mr. Avery's garage, which was allegedly fired from his .22 Marlin Glenfield gun. Not his, Raleigh Johnson's. C, the location of Ms. Halbach's RAV4 on the Avery salvage yard with Mr. Avery's blood and her blood on it. The human remains detection dog, Brutus, alerted on the RAV4, indicating that a deceased person has been there, which still never makes sense to me, ever. Why, if Stephen, I got to put bird seed in my bird feeder. Look at that. It's completely empty. Sorry. Squirrel. Why would Teresa ever be in the RAV4? It makes zero sense that if Stephen is shooting her in his garage and then putting her in the burn pit behind the garage, why would he ever be in that vehicle? Or she ever be in the vehicle? So the dog's alerting on that vehicle tells me it's a completely different scenario, not Stephen doing it, because there's zero sense of her, and her car was never in his garage. Look at his garage. It's never going in there. So, okay. Anyway, sorry. I get distracted a lot. Ms. Halbach's electronic, wait, did I miss this? Okay, sorry. D, Ms. Halbach's electronic devices in Mr. Avery's burn barrel. E, the RAV4 license plates near Mr. Avery's residence. Well, it wasn't. The RAV4 license plate was not near Stephen's residence. Because the license plate was in a car which was all the way down at the other end, actually was by where Chuck was living at the time. So it's down by the garage. So the plates were in a car down there. So, that's a quarter mile away from Stephen's residence. So it's not near his residence, unless by Mr. Avery, they're meaning Mr. Chuck Avery, but the plates were by Chuck's house. F, the RAV4 key in Mr. Avery's bedroom. Sweaty Sweat Sweat claimed that the proximity of Mr. Avery's burn pit to his residence was particularly incriminating to him. Sweaty Sweat Sweat specifically told the jury, this particular computer-generated animation is important to embrace or for a jury to look at in the case because the burn area is clearly visible. How close it is to Mr. Avery's garage, how close it is to the trailer, how close it is to the other area, what's called the curtilage, that is the area that surrounds Mr. Avery's property, all becomes important. Huh? All right, I've been there, and where all these different burn barrels are and where the burn pit is, they're not by each other. I don't know. Kratz is an idiot. In his closing argument, Mr. Kratz told the jury that the location of the bones in Mr. Avery's burn pit was the most important evidence of Mr. Avery's intentional murder of Ms. Halbach. Sweaty Sweat Sweat told the jury the following. We could start with the moment or with the visual or with the image of that man, Stephen Avery, standing outside of a big bonfire with flames over the roof, or at least over the garage roof, and the silhouette of Stephen Avery with the bonfire in the background, and the observation made by some witnesses. And that moment, by the way, although dramatic and although important, should tell the whole story. That garage is built out of particle board, cheapo wood. The burn pit is way closer to the garage than the law enforcement's pictures lead you to believe. If there was a fire over the garage, that garage is going up. Plus, there was the propane tank. So you've got the garage, all right, garage, burn pit, and then over to the side is that propane tank. And if nobody could tell for sure which Dassey kid it's down there, how do you know if there was a fire? Because I'm not even sure there was even a fire that day. How do you know that it was Stephen with a Dassey boy? How do you know it wasn't Chuck? How do you know it wasn't Earl? So, whatever, Sweaty Sweat Sweat. And what witnesses? At Mr. Avery's trial, his trial defense counsel, Jerome Buting, stressed the importance of the bones found in the Manitowoc gravel pit when he said, if that body was burned somewhere and then moved and dumped on Mr. Avery's burn pit, then Stephen Avery is not guilty, plain and simple. Now that is why the state has gone to such trouble avoiding the fact that the bones were moved. That's why you heard nothing about it here, because it does not fit with their theory that Avery is guilty. Sweaty Sweat Sweat stated in his rebuttal at trial, these bones in the quarry, I'm going to take 20 seconds to talk about because the best anybody can say is that they are possible, spelling intentional, human. They are possible human. Sweaty Sweat Sweat acknowledged the importance of having the bones identified as human, but he dismissed the defense claim that the bones were human because of the lack of scientific verification for that claim. Sweaty Sweat Sweat told the jury the events at these two locations, Mr. Avery's garage and burn pit, told the whole story, and only one person committed this crime. Yet two are in. Isn't that weird? Only one, but two. Therefore, the identification of the Manitowoc County gravel pit bone fragments as Ms. Halbach's is material because it is apparently exculpatory and potentially useful in proving the murder and mutilation did not occur in a location tied exclusively to Mr. Avery. No reasonable trier of fact could conclude that if Mr. Avery murdered and mutilated Ms. Halbach in the Manitowoc County gravel pit, he would move her bones from the gravel pit to his own burn pit and thereby incriminate himself. The state's illegal transmittal of the bones to the Halbach family is the next section. On December 17, 2018, Mr. Avery filed a motion to stay and remand this appeal for scientific testing of several suspected human bones recovered from the Manitowoc County gravel pit. Specifically, Mr. Avery proposed rapid DNA testing that has been successfully used to obtain DNA identifications from bones burned to a degree similar to those recovered from the Manitowoc County gravel pit. This testing, argued Mr. Avery, is relevant and material because the identification of the bones as Ms. Halbach's is compelling evidence that her murder and mutilation did not occur in a location connected exclusively to Mr. Avery. Therefore, no reasonable trier of fact could conclude that if Mr. Avery murdered Ms. Hallback in the Manitowoc County gravel pit, he would move her bones to his own burn pit, thereby implicating himself. Thus, Mr. Avery argued, if the rapid DNA testing identifies Ms. Hallback's bones in the Manitowoc County gravel pit, two inferences are reasonable. One, Mr. Avery is not the murderer. And two, the bones recovered from Mr. Avery's burn pit were planted. There is, therefore, a reasonable probability that such testing would undermine confidence in the jury's verdict. On December 28, 2018, this court denied Mr. Avery's motion, finding that the scope of this appeal is limited to a review of the circuit court's orders denying Mr. Avery's Wisconsin statute, blah, 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 motions, and that further scientific testing of evidence is not necessary to decide the instant appeal. After filing Mr. Avery's December 17, 2018 motion, undersigned counsel discovered a previously undisclosed police report, September 20, 2011. Specifically, a third party provided counsel with a copy of the report, attached and incorporated as Exhibit A. The September 20, 2011 report reflects the Calumet County Sheriff's Department's transfer of multiple suspected human bones from the Manitowoc County gravel pit to the Whiting Funeral Home for return to Ms. Hallback's family. Specifically, the suspected human bones from the Manitowoc Quarry, property tag numbers, blah, 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 were returned to the Hallback family, according to the September 20, 2011 report. The exhibits attached to Mr. Avery's December 17, 2018 motion describes the location of the suspected human bones in the Manitowoc gravel pit as reflected in Dr. Leslie Eisenberg's report. In 2016, Suzanne Hagopian, I don't know how you pronounce that, of the Wisconsin State Public Defender's Office, who had been Mr. Avery's prior post-conviction and appellate attorney, provided to undersigned counsel's office entire file pertaining to their representation of Mr. Avery. The September 20, 2011 report is not present in undersigned counsel's file kept on this case. On January 3, 2019, undersigned counsel contacted Ms. Hagopian to request that she confirm whether she had ever seen the September 20, 2011 report. Counsel has obtained an affidavit from her. In her affidavit, she explains her representation of Mr. Avery began in July 2007 and ended when the Wisconsin Supreme Court denied his petition for review on December 14, 2011. On September 20, 2011, she and her co-counsel, Martha Askins, were Mr. Avery's attorneys of record. Ms. Hagopian had no recollection of having seen this police report before undersigned counsel delivered it to her on January 3, 2019. Further, she does not recall having a conversation with a representative of the state pertaining to tendering items of evidence from Mr. Avery's criminal case to the family of Ms. Hallback. Moreover, she avers that had she seen this report or had a conversation with a representative of the state regarding the return of items of evidence to the family of Ms. Hallback, she believes she would recall it. Attorneys Hagopian and Askins filed Mr. Avery's Wisconsin statute blah blah post-conviction motion on January 29, 2009. That motion was denied by the circuit court on January 25, 2010. Holy cow, from June to January. And attorneys Hagapian and Askins timely appealed on February 10, 2010. This court affirmed the circuit court's order denying relief on August 24, 2011. Then, on September 20, 2011, during the pendency of Mr. Avery's appeal, the Calumet County Sheriff's Department, together with Assistant Attorneys General Thomas Fallon and Norman Gahn, arranged for the return of certain suspected human bones from the Manitowoc County gravel pit to the family of Teresa Hallback. On September 22, 2011, attorneys Hagapian and Askins filed their petition for review in the Wisconsin Supreme Court. That petition was denied on December 14, 2011. The state, without notifying Mr. Avery and his attorneys, and she has that and underlined, and during the pendency of Mr. Avery's direct appeal, caused material and potentially exculpatory evidence to be transmitted to the Hallback family for its potential destruction by cremation or burial. On January 24, 2019, undersigned counsel received her own copy of the September 20, 2011 report from the Calumet County Sheriff's Office and was able to verify the accuracy of the report provided to Ms. Hagapian. Because the state violated Wisconsin's Preservation of Biological Evidence statute, Mr. Avery's due process rights were per se violated. His conviction cannot stand. Wisconsin statute blah, blah, blah governs the preservation of physical evidence collected subject to criminal investigations, except as provided in sub 3, if physical evidence that is in the possession of a law enforcement agency includes any biological material that was collected in connection with a criminal investigation that resulted in a criminal conviction, and the biological material is from a victim of the offense that was the subject of the criminal investigation, or may reasonably be used to incriminate or exculpate any person for the offense, the law enforcement agency shall preserve the physical evidence until every person in custody as a result of the conviction has reached his or her discharge date. A law enforcement agency shall retain evidence to which sub 2 applies in an amount and manner sufficient to develop a blah, blah, deoxyribonucleic acid profile as defined in blah, blah, blah from the biological material contained in or included on the evidence. Subject to sub 5, a law enforcement agency may destroy evidence that includes biological material before the expiration of the time period specified in sub 2 if all of the following apply. The law enforcement agency sends a notice of its intent to destroy the evidence to all persons who remain in custody as a result of the criminal conviction, and to either the attorney of record for each person in custody of the state public defender. No person who is notified under par does either of the following within 90 days after the date on which the person receives the notice: files a motion for testing of the evidence under blah, blah, submits a written request for retention of the evidence to the law enforcement agency. No other provision of federal or state law requires the law enforcement agency to retain the evidence. It is beyond question that the state violated blah, blah when it failed to preserve the suspected human bone evidence and notify Mr. Avery and Ms. Hagapian, and I would say Brendan Dassey as well and his attorneys, of its intent to do the same because the suspected human bones were biological evidence collected in the course of the state's investigation of Mr. Avery, which ultimately led to his conviction. Additionally, the human bones were, at minimum, suspected of belonging to the victim in the crime of which Mr. Avery was convicted. Therefore, the suspected human bones recovered from the Manitowoc County gravel pit are properly considered within the ambit of blah blah. Because blah blah does not provide a remedy for convicted persons in the event of a violation, fashioning a remedy is left to the courts, an action Wisconsin courts have yet to take. Mr. Avery submits, what page am I on? This thing's so long. Sorry. Mr. Avery submits that the court should establish the most just and most logical remedy for such evidence preservation violations, i.e., such violations amount to per se due process violations. This conclusion is borne out by controlling United States Supreme Court. Blah, 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 blah. All right. I skip over when they talk about other cases to compare it to. You can read this yourself if you want that on these other cases. Let me scan through the other cases. Scrolling through. Sorry, still scrolling through. We don't need to read all of it, but I want to, all right. So this is from Calumet County Sheriff's Department. So this is an actual document that was used. It is type of activity, returned items. Date of activity, 9/20/2011. Reporting officer, Deputy Jeremy Hawkins. On 9/20/11 at approximately 9 a.m., I, along with Mark Wiegert and attorney Thomas Fallon and attorney Norman Gahn, removed from evidence all property tag names that contained human bone. Attorney Gahn and attorney Fallon viewed the items under the property tags and, along with Dr. Leslie Eisenberg's report, determined which bones could be returned to the Hallback family. Ledger number, property tag number, contents sifted from burn pit near Steve's residence garage. The human bones from property tag were removed from the container and photographed. Next one is unidentified material suspected to be bone and unidentified material charred were removed and photographed. Next one, unknown material suspected to be bone and bone fragments were removed from storage and photographed. Next one, the human bones were separated from the rest of the contents and photographed. Next one is burnt bone pieces from barrel number 2. The human bones were removed from the rest of the contents and photographed. Next one is suspected bone fragments and separated human bone was removed. Suspected bone fragments, the separated human bones were removed and photographed. Next one, suspected bone fragments, the separated human bone fragments were removed and photographed. Bone fragments, the separated human bone fragments were removed and photographed. All right, they're all saying, I'm not going to, okay. So after all bone fragments that were determined to be able to be returned to the Hallbacks by Attorney Fallon and Attorney Gahn were completed, the items were transferred to Whiting Funeral Home in the presence of Mark Wiegert and myself. The packaging for all the items returned and retained by the Calumet County Sheriff's Department in secure storage. All right. The next thing is an affidavit of Kurt Kingler. And he's a law clerk of Kathleen's. On December 19 and 20, under instruction of Ms. Zellner, I searched our Avery case file for a copy of the Calumet County Sheriff's Department reported dated September 20, 2011. Authored by Deputy Jeremy Hawkins. I'm sorry about my dog with the squeaky toy now. A copy of that report sent to Zellner and Associates by an interested civilian who was aware of the report had been produced pursuant to a third party's FOIA request is attached and incorporated herein as Exhibit A. Our case file includes, without limitation, the circuit court record transmitted to Mr. Avery by the state public defender, the trial file built by Dean Strang and Jerome Buting, the post-conviction and appellate files built by Suzanne Hagapian and Martha Askins of the state public defender, the files of prior post-conviction attorneys Thomas Aquino and Philip Hoff, the post-conviction file built by Mr. Avery, and the file built during Zellner and Associates representation of Mr. Avery. And then I did not find the September 20, 2011 Hawkins report in our case file as described above. Next one is this the same thing? The returned items with the Deputy Jeremy Hawkins. Yeah, that's the same thing. All right. Next thing is affidavit of Suzanne Hagapian. She says, in July 2007, I was appointed appellate counsel for Mr. Avery by the Wisconsin State Public Defender. My co-counsel, Martha Askins, and I represented Mr. Avery throughout his direct appeal until the Wisconsin Supreme Court denied blah, 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 blah. In 2016, the state public defender provided to the law firm of Kathleen T. Zellner and Associates our entire file pertaining to our representation of Mr. Avery. Prior to the Zellner law firm's representation of Mr. Avery, we had delivered to him all of the transcripts and our copy of the circuit court record. Thus, the Office of the State Public Defender has not retained any of its file from our representation of Mr. Avery. On January 3, 2019, the Zellner law firm sent me a copy of a Calumet County Sheriff's Department report dated September 20, 2011. I have no recollection of having seen this report before the Zellner law firm delivered it to me on January 3, 2019. Nor do I recall having a conversation with a representative of the state pertaining to tendering items of evidence from Mr. Avery's criminal case to the family of Teresa Hallback. I believe I would recall having seen this report or having a conversation with a representative of the state pertaining to the release of items of evidence. As noted above, Mr. Avery's direct appeal concluded on December 14, 2011, when the Wisconsin Supreme Court issued its order denying Mr. Avery's petition for review. And again, with that, showing that they had the bones thing again. All right, so that's the whole thing. So I've read it. I've read that all that we're gonna read. So we've discussed this before, and this is somebody that I know, Carol Ann Fitzgerald, who is a member of our groups, as well as I think like every Making a Murderer Facebook group there is, and on Reddit and such. She is one of the people that contacted Kathleen about this. And so what this means is Sweaty Sweat Sweat didn't want anybody to look at those bones that were at the gravel pit. The gravel pit is the location that is the farthest away from the salvage yard. You know, the quarry is right behind. So like where Teresa's vehicle planted, the quarry is literally like 10 feet from there. That you just walk up this hill and there's quarry. So for it to be in the quarry, it's still close by. The gravel pit is not right there. So there was what looks to be a pelvic bone that was in that gravel pit. I keep confusing what's gravel pit and quarry. So it makes no sense if there is part of Teresa way over there in the gravel pit. Why would Stephen do that? Why would Stephen murder and mutilate her and take her a ways away from the property, but then still put a whole bunch at his place? 0 cents. Zero. And as it's stated in there, the law is, as long as somebody is in prison, the evidence has to remain in storage so they can use it for testing. So, one, you're not, Sweaty Sweat Sweat is trying to get you to not look at those bones at all and claim that they are even human. Maybe they're human, maybe they're not. So he wants to pretend they're not human, yet they gave them to the Hallback family, which is violating on multiple levels, because you're saying that's not Teresa. So why does it go to the family? And the law says you can't give it to the family as long as Stephen's in prison and Brendan, it has to remain there. So like, even if you get Stephen out, if Kathleen's able to free Stephen and Brendan's still in there, he is still incarcerated due to this. So it would still have to remain in storage for him to use. So that's the big deal with this. We discussed it before that she was going to be filing at the end of December, and they put a pause on it while she filed that whatever, the remand for the DNA, the rapid DNA ID testing, which they say they would get the results within 2 hours. Is it human? And is it Teresa? And if that's the case, Sweaty Sweat Sweat's whole narrative falls apart. Because according to him, Stephen, in Stephen's case, Stephen shot her in his garage. And what? Then he shot her in the garage, then pulled her car in the garage, threw her in the back of the garage to drive her right behind his little garage. And wasn't there a creeper involved at some point? Not Kratz. I mean, Kratz is a creeper too, but a mechanic's creeper. Wasn't it stated at some point, like Stephen and Brendan? Well, Brendan is not mentioned in Stephen's case, but wasn't there something about them using a mechanic's creeper to try and transport Teresa's body behind? I don't know. So, but nowhere in his narrative is, we went out to the quarry and the gravel pit and sprinkled her body parts in various locations. So, and I don't know what this does with, and I'm just going to be scrolling down to the bottom of your comments because one of the moderators, Christy, told me she's been answering people's questions. So I don't need to scroll through things to see what to answer. Where was I going now before I got distracted with that? Sorry. It's been a long day and I've got such a headache. I don't know. She's supposed to be filing February 1st is the deadline. So, which is Friday next week, right? So I think that is still in force, that it doesn't change, that she still has to file February 1. So we'll be waiting for that. But so she's pursuing these bones, and where are the bones? Because they're supposed to be in custody, and if you gave them to the Hallback family, it's violation twofold. And those bones need to be tested. So if those bones are buried, they're going to have to exhume them. So, and for people who are going to be upset about exhuming the bones, Well, then maybe you should have been fairer to Stephen and Brendan to begin with. I know no family ever, they don't want their loved ones exhumed. I get it, but this is not justice. What Sweaty Sweat did to Stephen and Brendan. So, Angel says, drink water for my headache. Yeah, I definitely will be. So, what is this? Sorry. Let me bring this up. I just got a Google alert of, it's Kathleen just took on another client. So I'm getting a Google alert that she filed a federal lawsuit against a police department for somebody else. Anyway, all right. So that's where we are on the bones. It's a big deal. And even if they're not able to get the bones back, having them admit they gave the bones to the Hallback family is a problem because it's against the law. You can't do that. It has to remain in evidence. And if you're saying that the bone at the gravel pit is not Teresa, then why'd you give it to the Hallback family? So if you gave it to Teresa, you must think they're Teresa's bones. Therefore, your whole theory of how you allege Stephen killed Teresa is incorrect. So maybe you don't want to just open the doors and let Stephen out, even though that's what should happen. New trial. This case, I swear. Jill, no, I'm not a lawyer. I know nothing about the law. So don't ask me legal questions because I don't know. And no, the Hallbacks stay quiet. They don't say anything on anything. Sherry says, you would think they would want the real killer turn over the bones. You would think so. Monica says, where did Carol Ann find this report? Oh, somebody else might have already answered that since I'm too far up. I think it was Reddit. That Reddit was discussing it. So Carrie says, well, here, no, I'm just going to scroll to the bottom because I know the moderators are, okay, yeah, people are answering it already. All right, so I'm keeping this short and sweet because it's been a long day for me. And as I said at the beginning, my son and his girlfriend are coming over to make dinner and hang out. And I need to get my house picked up a little bit. But the leave with the filing is posted. So you can read it for yourself. And if anything else pops up, I'll pop on here and we can discuss. And we delve more into the case into our little subgroup that's currently called Gossip Project. It was originally called MAM Project. We had changed the name to Gossip Project since we discussed a slew of other cases there as well. But people wanted to go back to MAM Gossip. So we might be changing the name back at the end of the month. So Stephen Avery Project is where we just talk about the case. And then at Gossip Project, we delve more into everything there. So, all right, I am tuning out. And yeah, go read it if you haven't and look into everything and write Stephen a letter. We've got that pinned where you can write to Stephen, as well as how you can donate to his commissary or send money to Kathleen. She's got a page for Stephen where you can help with the legal costs. So, All right. Until next time.